very much. Thank you.
Chair, the next witness is Reverend Nathan Ward. Thank you. To take the oath.
I swear by Almighty God.
I swear by Almighty God.
That the evidence I shall give.
That the evidence I shall give.
Shall be the truth.
Shall be the truth.
The whole truth.
The whole truth.
And nothing but the truth.
And nothing but the truth.
Thank you. Please sit down. Can you give your full name to the inquiry, please?
Yes, it's Nathan James Ward.
And Reverend Ward, you've made 2 witness statements to the inquiry. The first reference is at DL quadruple 0141, and the second is at DL quadruple 0154. I'm going to ask you some questions about them, but I'm not going to go through every single topic or paragraph in the statements because those will be adduced into evidence in full, and so the chair will be able to take account of the contents in due course. Likewise, you've exhibited a number of documents to your witness statements, and many of those will be adduced in due course, and so I won't be taking you to those, or I'm unlikely to take you to many anyway, in the course of your evidence. If we deal with your current role, you're currently a vicar, is that right?
That's correct.
But you previously worked for G4S. When did you first work for them?
So I left university in 2001 and joined as a lay chaplain at Medway Secure Training Centre, which at that point was run by Group 4 and transitioned through until G4S finally ran it.
And I think in July 2012, you became head of Tinsley House.
That is correct.
Is that right? Were there some particular challenges you faced as head of Tinsley House when you started there?
So I actually started on a secondment to Brookhouse prior to that. After I left Medway, following concerns that I had there that I raised with the Managing Director of Children's Services, he arranged for the secondment to Brookhouse. And then following that, I was offered a job first as Head of Children's Services to set up the family suite following the Deputy Prime Minister's announcement to end child detention. And then, through some cost-saving exercises, became Head of Tinsley House, which also led me to be a duty director and part of the senior management team at Brookhouse.
And so what did your role at Brookhouse as duty director involved as distinct from your role at Tinsley House?
So the role of a duty director is that you've got strategic oversight of the operation of the centre for that day. You would attend unlocking. You would then have oversight of any movements that took place during that day. You would need to do Rule 40 and Rule 42 reviews. You would also oversee any ACDT processes, which is the process for suicide and self-harm within the centre. And then if there was any significant disturbances or incidents, the duty director would take up the role of a Silver Commander, which has the operational responsibility for the management of any incidents within the centre.
So this was a senior management role?
Yes, and it's part of the senior management team. So part of the cost saving was, instead of having 2 senior management teams, one for Tinsley House and one for Brookhouse, they combined it into one senior management team.
I see. And how much time did you spend from 2012 onwards at Brookhouse as opposed to at Tinsley House?
So because of staffing issues within the senior management team and people being off, I was duty director there at least 2 times a week, if not 3 times a week. And for example, if you worked a weekend, you'd be duty director on the Friday, Saturday and Sunday.
I see. And during the time you were duty director, you would be based solely at Brookhouse, would you?
Yes. So originally there was a duty director across both sites, and then it was decided for during the daytime hours to have a duty director based at Tinsley House, but the Brookhouse duty director would then take overnight calls for both centres.
And as duty director, did that role involve spending much time on the residential wings and engaging with detainees or not?
So duty directors approach the role in different ways. However, my management style is that it's very difficult, if not impossible, to run a residential institution from behind a desk. I used to spend most of the day out and about on the wings.
Thank you. You resigned from G4S on Monday, the 14th of April 2014, is that right?
That is correct.
What were the reasons that you resigned at that time?
So the reason for my resignation is that for a long time I tried to reform the institution from within, but there came a point where actually I was only perpetuating an unjust, inhumane and what I consider to be a barbaric system which I could no longer be part of, and that was a system that essentially was incompatible with my faith too, and that's the reason why I left.
In your statement, you mentioned that in 2013 there was a change in senior management. There was a new deputy director and director Ben Saunders being brought in along with Steve Skitt. And you say that things deteriorated after that time. What exactly was it, in your view, that deteriorated?
So what happened within the centre during that time is that it was eminently clear that they didn't have the skills and experience of immigration. Ben Saunders had come from children's services. His whole background was in children's services. Prior to Medway STC, which was a 76-bed, he worked in a children's home, a secure children's home, which I believe only had 12 beds. And now we're expecting him to run a centre of over 400 beds. And essentially, I think the operation deteriorated, the morale of staff deteriorated, the care of detainees deteriorated, the fabric of the building deteriorated.
After your resignation, you had an exit interview with Jerry Petherick, who was the managing director of G4S, and Alison Ashcroft from Human Resources. What was the purpose of that exit interview?
So following my resignation, they had asked to meet with me at the G4S office by Victoria, number 5 Victoria Place I think it is, or something like that. And they wanted to know the reasons why I left. To prepare for the meeting, I made bullet point notes, which is part of the evidence bundle, and went through that systematically, and both Alison and Jerry took notes in their personal notebooks.
And some of the concerns that you raised concerned the management of Brookhouse?
Correct.
And some concerned what you've described as being the culture of Brookhouse?
Yes.
And some of them were personal to your own employment with G4S?
Yes.
Looking then at Brookhouse itself, in your statement, for everyone's note, it's paragraph 67 onwards, you give your view that there were 3 main flaws which allowed the mistreatment of detained persons seen on Panorama to happen. And the first, you say, related to the fact that Brookhouse was intended to be a 72-hour centre.
Yes.
You record at paragraph 69 that the bid submitted to run Brookhouse by GSL and the proposals for how it would be operated were prepared on the basis that it would only hold detained persons for a short period of time, namely 72 hours. Did the contract following the awarding of that bid also reflect that it was to be a short-term facility?
So what was interesting is that the design and infrastructure was designed for 72 hours, and actually in the Home Office evaluation of the GSL bid, they were scathing and set out their concerns which were more than significant. And therefore, at the very outset, the Home Office had concerns that they wrote down to state that this wasn't going to work. and yet they still approached the contract and gave it to GSL. And when G4S took over the contract, they would have done due diligence on that contract as well. And therefore, from the outset, everyone knew and had concerns that this wasn't going to work. And indeed, it didn't work. And in relationship to the 72 hours, the design of it was for 72 hours, but that wasn't explicit within the operating contract. However, when you read Schedule D, and in particular the anticipated throughput, which is set out contractually, it all points to a short-term holding centre.
So we know that the capacity at the time was 426 detained persons, and the contract suggests that there were to be 2,500 detained persons to be processed per month, and that you say suggests that they were to be held there for only a very short period of time.
Yes.
Ben Saunders reviewed the contract in June 2014, and you mentioned that in your statement at paragraph 71. What did that review say about the throughput of detained persons?
So can I draw? Do you
Yes,
want to
perhaps
point me to it?
I can ask you in this way. In that review, he noted that the current throughput was typically 1,200 to 1,400 detained persons per month, and it had been at that rate for over a year. Does that suggest that detained persons were being held there for significantly longer than 3 days generally?
Absolutely. There's a dearth of evidence which supports that people stayed there for far longer than 72 hours, and in some cases in excess of a year.
And what's the significance of a lower throughput of detainees for G4S? Does that have a particular effect on the cost of running Brookhouse?
So to all intensive purposes, if you've got lower throughput, you're buying less clothes, you're buying less shoes, and those things, the consumables are a lot lower, and therefore, to all intensive purposes, it's cheaper to run on a lower throughput. I think the review that you draw our attention to also states, Ben Saunders stating the inflated profits that G4S were making out of the contract at that time, and I would say that would be a significant disclosure.
You also detail that, in your view, the design and the specification of the building weren't designed for holding detained persons for longer periods of detention. What was it in particular about the design and the specification of the building that affected that experience?
Yes, so Brookhouse was designed as a Cat B prison. And when you look at the facilities within Brookhouse, there's very limited spaces for association, recreation. When you look at the history of custodial architecture, you will see that Brookhouse is in stark contrast, and in fact is just a pure building of function, which doesn't meet the needs of most human beings. The 7 lamps of architecture that Ruskin sets out have been clearly avoided by the architect of Brookhouse. It doesn't bring any life or flourishing to human beings whatsoever.
So there was an impact on the actual regime that was run in Brookhouse.
Yes, to understand the abuse that took place in Brookhouse, we must start with the bricks and mortar, and they themselves were abusive in form and nature.
What was it about the particular building, the bricks and mortar, as you say, that was abusive?
So for human beings to live, and indeed not just live but flourish, we need things like natural daylight, natural air. We need things which raise our minds and our souls, none of which are present in Brookhouse, which is essentially a holding factory for the purposes of removing people.
And did the design and the specification of the building have an impact upon the activities and welfare provision that was provided in Brookhouse?
Absolutely, because there was no space for the activities where, if you contrast them to somewhere like Tinsley House, you had a sports hall, you had an outdoor pitch and such things. You had association rooms, we had a cinema room. There was no space for that. What there was essentially 4 wings, 3 of which had 3 levels, with noise going around, so it was a noisy environment, it was a smelly environment, and there was no place for calm or solace.
And what impact do you think that had on the welfare of the individual detained persons who were resident in Brookhouse at the time? How did it affect them?
Yes, so I think there's overwhelming evidence that people within Brookhouse that maybe came in without any mental health issues saw deterioration in their mental health. I draw a reference in the statement, for example, to the amount of medication used to help people sleep at night, which was extraordinary, which is all factual evidence that says that the environment was inhumane in its nature, let alone any behaviour from staff.
And so did you have experience yourself when you were there of people being detained in Brookhouse for longer periods of time than a few days or a matter of weeks?
Yes, and I had personal experience of people being detained at Brookhouse, being released from Brookhouse and being re-detained at Brookhouse.
And how did that affect them?
I think it's demoralising when any human being is in a position where their liberty, to all intents and purposes, has been taken from them, where they have no concept or idea of when they will be released. We would refer to it as indefinite detention, or some might like to call it indeterminate detention. That is most demoralising, and it is a system without hope. And as Deborah Weston, the centre manager at Tinsley House, stated to me, which kind of captures the essence of it, it's all down to who breaks first, the Home Office or the detainee. And my personal experience of being at Brookhouse is that is exactly how the system played out, and that is a system which has no place in a just, humane society.
You've mentioned the mental health of detained persons. Were vulnerable people particularly affected by prolonged detention?
So I'd like to rephrase it and say vulnerable people were affected by detention, full stop. The policies of the Home Office, although you could say are woefully inadequate, they clearly state that those vulnerable people should not be placed into detention in the first place. And therefore, when we see that people that are vulnerable with mental health issues end up in detention, that is clear evidence of systemic failings of Home Office policy and practice. And the Home Office cannot deny that they were unaware of such things because the systems were in place to tell them. The IS 91RA Part Cs were in place.
I'll just pause you there for a moment because I'll move on to that a little later in your evidence. I just want to ask you about what your experiences of seeing what was happening in relation to the mental health and what you witnessed firsthand in relation to detained persons. Were there particular incidents occurring, in your view, because of a deterioration in vulnerable people's mental health because of their detention?
Yes, so I've witnessed people who have sewed their lips together. I've witnessed people who have been on what's called dirty protest. Now, that isn't something someone with good sound mental health does. I've witnessed people on food and fluid refusals. I've witnessed people seriously self-harm. I've witnessed people people attempting suicide. I've witnessed people crying, showing me the scars of torture, whilst holding letters from the Home Office denying their claims of torture. I've commanded incidents where people have stood on the wrong side of the railings with a ligature around their neck on the phone to their 9-year-old son saying goodbye. These are just a snapshot of the things that I have personally witnessed.
And was that in Brookhouse alone, or in both Brookhouse and Tinsley House?
So the incidents, all of which I've referred to, are in Brookhouse. We had issues at Tinsley House too, but they were less frequent, is the easiest way of describing it.
Moving on then to what you've referred to as the second floor, you've mentioned that Brookhouse was designed as a Category B to Category B prison specification.
Yes.
The categorisation, the security categorisation is a risk management process, is that right?
Yes.
And its purpose is to ensure that those sentenced to custody or detention are assigned to the lowest security category appropriate to managing their risk.
So within the prison estate, that is how it is set up, that is correct.
And so what does a Category B specification mean in practice in an immigration setting as opposed to a prison setting?
So within an immigration setting, it is more secure, it's more austere in nature, there are more locks, and the cells are different too, and it's the open space as well. That's kind of some of the core differences of categorisation. But it should be noted that within the immigration estate, they don't necessarily use the categorisation to the same extent of the prison service, but the principle is still there, and they would place more difficult or challenging people in Brookhouse opposed to places such as Tinsley House.
And how did that Category B specification affect the experience of staff and detained persons at Brookhouse, in your view?
So I think the Category B prison came about first and foremost after the disturbances at Yarlswood IRC, and therefore it was a response to protect politicians opposed to containing people within it. And I think that's the first important part to note. And also, for example, even within Tinsley House, we had a free and open regime, and yet in the Home Office corridor, the immigration interviews took place with the chairs chained to the tables for the protection of the immigration officers. And actually, when we think then about the impact on detainees, we are by definition placing them in more constrained environments, which is fundamentally unnecessary. How can it be that the day before coming into Brookhouse, the British government have said that it's okay for them to walk the streets of the local community, and then the next day, without going before a judge, we're placing them into a Category B prison? That seems perverse.
And how did that affect the staff's perception of detained persons? How did that affect the way staff reacted to the detained people who were at Brookhouse?
So the issue with placing them in a Category B prison as well is that risk is constructed, and therefore, as far as staff are concerned, they would interpret the context in which they work as being risky, and therefore the people contained within the Category B prison must be people of risk, which then fundamentally impacts the relationship or lack of relationship that they have with those held there.
You've referred to a third floor in Brookhouse, in that the contract to run Brookhouse was driven by cost cutting and profit rather than the care and welfare of the detained persons resident there. Is that right?
That is correct. Welfare is addressed within the contract, but actually when you look at the performance points awarded, it's very evident that actually welfare is an addendum opposed to the raison d'etre, as it were. It's clear that from the Home Office's point of view, the removal centre was there to remove people from the country. And it's that whole overarching conflict between having an open policy of a hostile environment whilst having a detention centre rule that says it should be humane. Hostile and humane aren't really used in the same sentence.
And what specific impact do you consider then that that incentivising of cost cutting or profit had on the welfare and safeguarding of vulnerable detainees at Brookhouse?
So when you have the Home Office just interested in deportations, and when you have G4S by definition interested in profit, welfare isn't really on the agenda. It's more around ensuring there's no embarrassments. So we don't want people to die, for example. We don't want people to die following food and fluid refusals, and that's why we see a pattern of people suddenly being released from detention if it goes too far. And I think that's the key for me. And part of me would ask the inquiry, how do you provide welfare in a system of indefinite detention where there is no hope? Providing welfare, in inverted commas, is like selling Christmas to turkeys. It's incompatible.
And did this priority also affect staffing provision, for example?
Yes, so staffing is based, as far as the contract is concerned, around maintaining good order and discipline and ensuring removals. So it's all focused around making sure that the immigration process runs smoothly. So not getting detainees to immigration interviews late is a key priority. Not hampering removals is a key priority. And I think it's important at this stage to make it abundantly clear that I firmly believe that the British government have a legitimate aim in removing people from this country, and therefore those tasks are important and indeed necessary. But actually it's the way we go about those tasks which is what we need to be focused on.
At paragraph 95 of your statement, you deal with the fact that in March of 2013 there was an increase in the capacity of beds at Brookhouse of 22. And then I think there was a further increase of 60 beds in around 2016.
Yes.
What was your view about the reason behind those increases?
So there was a need from the Home Office, or a perceived need from the Home Office, to increase the immigration estate.
So it was a Home Office decision to increase that capacity, from your knowledge?
If I can explain both parts, and then it will become clear at the end, if that's okay. So there was a perceived need of needing to expand the immigration estate, and obviously to build new immigration removal centres is expensive. But also, from G4S's point of view, you'd always be looking for ways to increase your profit. And actually, increasing bed space is the easiest way of doing that. And therefore the proposal, I believe, came from G4S to the Home Office, giving them an operational solution in which to increase the capacity at Brookhouse, which by turn increases the number of beds within the immigration estate without having the capital cost of building a new centre. However, when you look at the facts, the question has to be asked, do they actually need the increase in beds or not? Because the amount of successful removals at the time was around 50%. So actually, if you can filter the people coming in the first place, by definition, you would need less beds, and by definition, you would have a cheaper system.
The increase of the 60 extra beds in Brookhouse in 2016 effectively meant that some rooms were 3 people to a room.
Yes.
What effect do you think that increase had on the welfare and the well-being of detained persons living in those rooms?
So what was clear was that actually just a cell with 2 people in it was stuffy. The air was stale, it smelt, there was no access to fresh air, there was no real privacy when they were using the toilet, and therefore if the system doesn't work with 2 people in a room, adding a third person only increases the detrimental impact on living in there. If you're having to medicate people in order to sleep with 2 people in the room, then actually adding a third person isn't going to make it any better. In fact, it will make it demonstrably worse. And these are concerns which I actually raised at the time. And I drew the facts of some of the policies which are in existence around minimum sizes that should be given for cell space to Ben Saunders at the time, and suggested that in fact we weren't meeting those with 2 people, let alone 3 people.
And what was his response?
He said basically, thank you, but don't share that with the Home Office.
And so did anything change following you raising concerns in that way?
No, as you state, the extra beds went ahead.
Just moving on to some of the provisions of the contract, you've touched upon this, but I just want to ask you a few more questions about that. The contract between G4S and the Home Office provided for a system of penalty points within it, is that right?
That is correct.
And penalty points effectively equated to fines, a reduction in the fixed fee that was paid to G4S for the provision of the service of running Brookhouse.
Yes.
Those, as you've mentioned, were contained in Schedule G. I'm not going to take you to the document unless you need to see it, but I just want to ask you about a couple of elements within Schedule G. Abuse of detained persons was not a specific failure within Schedule G that attracted penalty points, but were there penalty points awarded if there was a substantiated complaint against a member of staff?
Yes, the penalty points would be awarded against a substantiated complaint, and therefore there was a great effort not to substantiate complaints.
And so within the contract, a serious complaint against a member of staff would encompass a complaint of assault or damage to or loss of a person's property or racial abuse.
Yes.
Is that right? The penalty points awarded were 300 for that type of substantiated complaint. What, in your knowledge, to your knowledge, does 300 penalty points equate to in financial terms?
So I think I addressed that within my statement, where I actually give the unit price of a penalty point. And I don't know if you've got the relevant paragraph to hand there that we could go to and give the actual answer.
Yes, it's paragraph 100, and you say that 300 penalty points would be £408 because 1 point equates to £1.36.
Yes.
Does that sound about right?
Yes, and the penalty points at Tinsley House were less than £1.36, which again is contained within the statement. And I think a point to note in relationship to Schedule G is that this is where the contract itself is woefully actually inadequate in the sense that if you think about the contract in percentage terms, Schedule G only deals with around 5 to 10% of the contract, so you can pretty much not do 90% and not be awarded any points.
Other aspects of Schedule G that might be described as relating to the welfare of detained persons, there were penalty points to be awarded for any failing to make available for facilities for religious observance.
Yes.
Is that right? Also 300
Yes.
Points. There were also penalty points to be awarded for self-harm by a detained person resulting in injury.
Correct.
And that would attract an award of 400
Yes,
points.
although I'm unaware during my time there that that element of the contract was ever used.
So during your time at Brookhouse, there were never penalty points awarded for a detained person inflicting self-harm.
Correct, to my knowledge, which, when you think about the number of ACDT cases which documented evidence of self-harm, you would say that something has gone awry.
So during your time at Brookhouse, you were aware of detained persons on ACDT forms?
Yes.
And those forms are opened when there is a concern that a detained person is at risk of self-harm or suicide?
Yes.
Were you aware during your time at Brookhouse of detained persons inflicting self-harm that did indeed result in injury?
So on a number of occasions as a GT director, I would be made aware that we've had to have called an ambulance to the site to deal with detainees who have hurt themselves, and therefore I would suggest that if we're calling an ambulance, even when we've got on-site healthcare staff, they have indeed inflicted injuries on themselves.
You deal with some figures in relation to the incidences of self-harm in your
Yes.
statement at paragraph 101, and you detail that in 2010 there were 39 incidences, in 2014 84, and in 2017 54 incidences of self-harm, but you're not aware of G4S ever having been fined for those.
Correct.
Do you know why they were never fined?
I do not know. We'd have to ask the Home Office that question. But more importantly, I think we need to ask the wider question, because financial penalties, with the greatest respect for a multi-million pound company, when we're only charging £1.50 odd, are irrelevant. Our focus should be more on preventing it happening in the first place, actually running a centre where people don't want to self-harm, actually running a centre where people who are vulnerable with mental health issues don't actually end up in the first place. And
Yes.
I think that should be the focus more than giving out the fines in the end.
Yes, indeed. Were you aware whether incidences of self-harm resulting in injury were underreported by G4S to the Home Office, or do you think they were reported and it was the Home Office whose decision it was not to levy those fines for the penalty points?
So the Home Office would be made aware of any open ACDT case within the centre, and they would also take part in reviews of ACDTs as well, and they'd be made aware through the IS 91 RA Part C paperwork. So the Home Office were aware through many different sources. They would be aware through the morning meetings where these things were discussed. Why they didn't levy the points through Schedule G is a question for them.
Thank you. And I'll come on a little more to those aspects you've just mentioned, but I first just want to deal with staffing levels.
Yes.
At Brookhouse. It's at paragraph 114 of your statement. And you start by saying that there was a major issue of understaffing at Brookhouse. What impact did that have upon the staff who were working at Brookhouse at the time?
So it's demoralising. As soon as you would walk into the building and collect your keys and radios, you would know that you were understaffed that day. Two of the primal fears of staff are being left alone, being isolated, and being attacked. And where you're placed in a position where there is lower staff than you expect or indeed need, then actually your fears are raised. And what that does in turn is that changes your natural responses to how you actually engage with the people in your care. Actually, you become more cautious, and as it's well documented, you move very quickly into a fight or flight mode of working. And that was apparent, especially when there was low staff. And the low staff, I would add, was by, in many ways, design in order to save money, because we were paid as G4S a flat rate for staff. If there was a vacancy, we didn't give their salary back, we would keep it, and essentially that would hit the bottom line.
So in terms of how the contract dealt with staffing levels, G4S, as you've said, were paid a fixed fee.
Correct.
And they would still be paid that fee even if there wasn't the full complement of staff.
Correct.
There were understaffing penalties to be applied, though, is that right?
Yes, but again, when we look at Schedule G and how they awarded penalties in relationship to staff, it doesn't actually correlate to the staffing profile which was placed into Schedule D of the contract. When we look at the staffing profile within Schedule D, what we see is the Home Office have agreed set numbers of staff for different periods during the day. And yet in Schedule G, they only monitor a 24-hour period, which means if you had overstaffing at certain points of the day, you can be understaffed at other points and not be awarded penalty points. And therefore, yet again, Schedule G was not fit for purpose.
So just to look at that then, the Home Office monitored staffing levels by total number of hours of staff work.
Within a 24-hour period.
Within a 24-hour period. But actually the contract had stipulated numbers of actual staff members, so the actual
per hour,
people.
I believe.
Per hour, and per shift.
Yes, and that was split from weekdays to weekends, and I think there was even one for bank holidays. But that, again, is in Schedule G.
And so which is the preferable way to measure staffing levels in your view?
So I think the only way is if you've issued a contract that's been evaluated on risk, even though we acknowledge that the evaluation showed that it wasn't going to work, then actually the staffing has to be based on that risk model. Any other basis for evaluating the staff per day is utterly nonsense, because actually we've said to deal with the risk at these different parts of the day requires these different members of staff at different parts of the day, and therefore we should be monitoring against that. For that is the bid which won the contract.
And it's not just about number of hours, it's about the skill set, the experience and the different roles of the actual members of staff working.
Yes.
What impact did understaffing or a lack of the correct staffing have upon the regime and the environment at Brookhouse, in your view?
It was utterly detrimental, and I'd draw the inquiry's attention to the Wolf report, which took place after the prison riots, which set out these key issues which we're talking about now. Understaffing having a detrimental impact on the culture within the centre and on the services provided to those in care. And actually, it was seen as a key issue that should be addressed within the prison service, and yet 10, 20 years later, we fail to learn those lessons within this context.
You also comment upon being aware of misreporting of staff levels at Brookhouse. What was it that was being misreported?
So during my time at Brookhouse, I shared an office when I was duty director with Michelle Brown, who at the time was the senior manager for central services, which included the reporting. And she alluded to the misreporting of staffing to G4S, and that she had raised concerns herself with Ben Saunders regarding that, and Duncan Partridge, the deputy director at the time.
And so when was that exactly?
So that was, I believe, 2012, 2013, and there was movement of staff between Tinsley House and Brookhouse as well to shore up the numbers, and so there was a strategic decision made that we would take a penalty hit at Tinsley House because essentially it was cheaper to do it there than at Brookhouse.
And you refer to Michelle Brown bringing that practice to your attention.
Yes.
She was responsible for ensuring the staffing levels met the contract, is that
Yes.
right? And you said she reported it. Are you aware of any response she received?
No, I'm not aware.
Did you personally report it any further?
I didn't personally report that any further because I didn't get involved with staffing. As a duty director, essentially you just had to deal with what you was given on the day. But what was clear to me was that when I used to turn up at Brookhouse as a duty director and was given the rota, or the roster as it was called for the day, there were numerous occasions where members of staff that were on long-term sick, for example, were in fact rotated for that day, which is endemic of a culture where A, you haven't got a grip on the operation, but B, your paperwork isn't reflecting the reality of the operation.
I want to move on then to another topic. You discuss in your statement that the detained persons and their experiences made them particularly challenging to work with at Brookhouse. What was it about them and their experience which made them particularly challenging to work with?
So I think I'd like to rephrase that, because the way it's phrased is that those people as human beings are particularly challenging, where actually the context in which they are forced to live is the thing that brings the challenge. And the basis where I would start is where you have people in a system who are already vulnerable, as members of staff who aren't equipped to deal with these challenges, aren't equipped to deal with significant complex mental health needs. Where that ends up is that as human beings we need to work out a coping strategy. So as members of staff, how do you cope with the trauma that you're presented on a day-to-day basis? And either within fields of social work, you would have what's called clinical supervision, something which doesn't take place or even exist within the context of an IRC. So what I observed over the many months and years that I worked there was that in fact staff ended up coping by simply dehumanising the people in their care.
Just pausing there, I was asking about what the particular experience of detained persons meant that it was particularly traumatic for staff to deal with them. Were there particular incidents or types of incidents that you witnessed that you found traumatic?
Yes, I've witnessed. I think this is where we need to break it down and be very simplistic. I found it traumatic that I found myself in an environment where people's liberty was taken from them without any end. That in itself for me is traumatic. I found it traumatic when I responded to a bell within a cell and opened the flap and the person had placed a plastic bag over their head in an attempt to suffocate themselves. I found it traumatic when people were self-harming. I found it traumatic when people were placing ligatures around their neck. I found it traumatic when they were showing me scars of torture. and letters. I found it traumatic when people were telling me that they were homosexual, and the Home Office had said to them, well, they didn't need to state their homosexuality when they returned to their home country. These things, individually and collective, were traumatic. It's traumatic seeing visits where detainees are holding their children and not being able to see them.
Were staff members given any particular training or support to deal with those aspects of what they were seeing and dealing with?
So, in one sense, I'm not sure what training is actually available to help people deal with the horrific incidents which took place. And to say that there was a staff support line with telephone counselling pales into significance, I would suggest, when you're having to deal with that, where in other contexts, such as social work, you would have the clinical supervision to help you unpack that and work with that in a more positive way.
I think there was mental health awareness training for detention staff in Brookhouse. Were you aware of that?
So I think there was that later on during my time there, that's correct. But again, it's...
We'll just pause there. What did it cover?
I don't know, because I never attended it. And I think it was only for an hour or 2 hours, if that. And when you think about some of the detainees that were held at Brookhouse ended up going to secure mental health provision, a 1 or 2 hour training session on mental health awareness is a bit like having to deal with open heart surgery after going on a St John's Ambulance first aid course.
Was there training provided specifically on suicide and self-harm risk and management?
Yes, so staff were trained in the ACDT process, which involved insight into suicide and self-harm.
And who was that training provided by?
So that was training provided essentially by the prison service, and then there was people who were trained to deliver it locally. And one of the issues I would suggest is, again, it locates suicide and self-harm as a behavioural issue where, in fact, we should be dealing with it as a mental health issue. And therefore, suicide and self-harm should be a process that's managed by the contractor for NHS England, because then it holds it in the correct context. All the time that we take it out of healthcare, we reinforce the narrative that this is a behavioural thing, when fundamentally it's not. It's a mental health issue.
And so did that training happen without any clinical input?
I think a nurse had some input, but the majority of it wasn't done by a healthcare professional, no.
And do you know, did it cover the types of things that you've just been discussing, that detained persons could be very traumatised, perhaps through their experiences in their country of origin, through being victims of torture, or have developed PTSD as a result? Do you know if it covered those type of areas?
Off the top of my head, I'd need to refer to the actual training documentation.
Do you know whether there was any separate or more specific or comprehensive training specifically to deal with detained persons who were victims of torture for staff?
So I'm aware that some staff went on some training, believe with Amnesty International. During my time there, I actually approached a charity, Medical Justice, to deliver training within Tinsley House around torture, but unfortunately, due to the pressures of the charity at the time, we was unable to make that happen. When I set up the family suite, I thought it was imperative that the staff there had good solid training on mental health, and therefore I brought in a psychologist to deliver a day's training on key mental health issues.
But that was at Tinsley House.
That was unfortunately not unfortunately, that was only at Tinsley House.
And in terms of the way suicide and self-harm risk was managed on the ground, was there a level of coordination between detention staff and healthcare staff?
So healthcare staff would attend, but it was led mainly by initially the ACDT assessor, and then we'd have people trained in that process that would form part of it. However, the way in which ACDT was designed out of the Prison Service Act model didn't really play out in practice, in the sense that you should have a multidisciplinary approach. You should have chaplaincy there, you should have healthcare there, and it was more often than not that you wouldn't have that comprehensive team. But again, I must stress, Chair, the mere fact that we're having to do this underlines the point that actually we had vulnerable people suffering from mental health issues in an institution where they shouldn't have been. Why would we need to train staff in mental health if the policy of the Home Office was in fact enacted and people that were vulnerable to mental health issues were prevented from going in there as they should have been?
So just dealing further then with the ACDT process and the policies and procedures, you've talked a little bit about it. This was the process of opening a log in relation to a detained person in order to manage their risk of self-harm or suicide. Is that
Yes.
right?
There would be a care plan as well, which was designed to give support to them during that time. But as I've said previously, what support can you give someone who's in a process of indefinite detention and due to be returned to a foreign land?
And so your view then was that the ACDT policy and procedure simply wasn't fit to be used in this particular context?
I would say it wasn't fit for purpose. It was designed for prisons, and actually it should be more NHS England, which have their own policies and procedures and practices for dealing with suicide and self-harm, that would seem more appropriate for this context.
And was part of the problem with the process that it was primarily run by custodial staff with little input from healthcare as a risk management process in order to manage the risk of someone committing acts of self-harm or attempts at suicide, rather than dealing with underlying issues or providing therapeutic input?
So I don't believe it was ever designed to deal with underlying issues, and it sounds terrible to say this. I honestly believe that it was in place to essentially keep the person alive so that they may be deported.
Some detained persons who are managed on an ACDT form and procedure were subject to constant observations in order to manage their risk. Is that right?
That is correct.
Did you have some concerns from your experience as to how constant observations were carried out?
So constant observations at Brookhouse, where possible, were carried out in a constant observation cell, which was fitted out as such during my time there, which essentially is a stark, empty room with a cell door which has been modified to have polycarbonate in it, essentially creating a fishbowl for staff to observe the person through it as well. And part of me just wants to point out even the language that we're using today, Chair, in relationship to this is significant. You wouldn't expect doctors to talk about managing people and stuff like that. Does that make sense? These are patients in the context of mental health, and I think that's important to note.
Did you have particular concerns that the way that constant observations were carried out on detained persons was dehumanising to them?
Yes, it was. It was dehumanising because essentially it was detached. Someone sat on a bar stool the other side of a locked polycarbonate door observing someone who, to all intents and purposes, has nothing to do in that room. Is dehumanising. At Tinsley House, we try to avoid that at all costs, and actually we would have the door open because again, these people, the risk that we've highlighted isn't one of violence against staff, it's one of them hurting and injuring themselves. And therefore, we would want to engage with them in conversation, in activity. We would have people on constant observation, walking around the centre freely and having a normalised regime. And actually, when someone at Brookhouse was on constant observation, by definition, they didn't have access to the full regime. And there was nothing in policy or procedure that removed their ability to access that.
And as we've already dealt with, at least touched upon, it wasn't a system that was designed to provide treatment or a health or therapeutic intervention as such. It was about the management of risk.
Yes, and that was profoundly highlighted in the incident, which I think the inquiry chair has watched many times, of someone hurting themselves with a nurse and a group of staff simply onlooking as some spectator sport.
You talk a little bit more about this culture of dehumanisation, as you've described it, in terms of the institutional culture at Brookhouse at paragraph 135 onwards of your statement. What was it about the working environment in particular that you think led to the mistreatment of detained persons at Brookhouse that's seen on Panorama?
So I think the mistreatment has come about through a collection of issues. The first one is fundamentally that the government have announced that they wanted a system which was a hostile environment. And therefore, what we see in Brookhouse is that hostile environment played out in real life. What we see in practice is a system where the policy has systematically failed, and vulnerable people with significant and profound mental health issues are found within Brookhouse. We find ourselves in a system where staff are having to deal with that trauma and simply do not have the skills or ability to manage that, and therefore the only way they can manage is by dehumanising the people in front of them. And at the point of dehumanisation, you're in the slippery slope to despair, which we see at Panorama. But what should be noted is that this isn't and cannot simply be cured by training staff. That is the biggest mistake that this inquiry could ever make. We need to overhaul policy, procedure and the system.
Was there a particular relationship, do you think, between a high incidence of mental illness and self-harming at Brookhouse and that dehumanising staff culture? Did the one impact the other?
Yes.
And in what way?
So the more they have to deal with, the more constant it is, and therefore the more they need to actually separate themselves out in order to come into work the next day. When we hear stories, and I've spoken to many staff who have to stop on their journey to work and be sick on the side of the road because they cannot face what might happen during the shift, that is the impact that this has on staff working there.
And so you mention an us and them mentality. Is that what you're describing there?
Absolutely, and even within the staff culture itself, there is an us and them mentality where the good people are sidelined, and I believe you've already heard evidence from Mr. Syred around how he was sidelined too.
You mention in your witness statement at paragraph 143 that you witnessed a culture of perceiving non-compliant behaviours by detained persons as disobedience, as opposed to a manifestation of trauma or mental illness or distress. What impact do you think that had on the way staff treated detained persons?
They had very little context in which to hold the reality that was before them. And therefore, the default position was that it was detainees choosing to be awkward, choosing to make their life difficult, choosing to make it a difficult shift, and therefore that evoked the response that we see in Panorama, but even on smaller levels. When a person needs toilet roll, they need toilet roll. To tell them they need to wait for the wing office to open is simply perverse, and that says something, doesn't it, of actually the system and how it is run.
Do you think that it led to an inappropriate or an excessive recourse to the use of force against detained persons?
Yes, so when people are trained in use of force, they're trained that it's to be used as a last resort. But if you only have 3 tools in your pocket, you're going to end up at the last tool very quickly, and therefore more emphasis is needed on preventative measures. And throughout my training and research into conflict management, that starts with the actual bricks and mortar itself. Then you need to look at the regime and making sure there's a purposeful regime, because all of these things prevent you ending up in that hostile, violent conflict. And then again, people need to be trained in conflict management. The largest part of an ITC course, the initial training course, is in fact CNR, which is the physical application of force, where actually you would hope that the balance is more on communication skills and de-escalation.
And so to what extent did that sort of process and reaction to those non-compliant perception behaviours amongst detainees lead to their removal from the wings to CSU or to E-wing?
So that would be kind of your default position of use of Rule 40, Rule 42, for example. But then there was that placing some detainees onto E-wing under the auspice that they would be easier to manage there.
And did that present a risk in itself in relation to staff's behaviour towards detained persons on the CSU or E-wing?
So I would say that CSU E-wing was a more hardened environment. Your balance of staff versus detainees was higher, and therefore staff would feel maybe more empowered to enforce rules. But also what it created is a toxic cocktail where you had the most vulnerable and the most violent inhabiting the same space.
Thank you. Chair, I'm conscious of the time. That might be a good moment for a 15-minute break, if you're in agreement.
Absolutely. So we'll return at 3:10.
Thank you.
Thank you.
very much. Before the break, we were dealing with the ACDT process. I'd like to move on to Rule 35 of the detention centre rules. We've
Yes.
heard a bit about that already. It's where a medical practitioner is required to report to the centre manager under subsection 1, where a detained person's health might be badly affected, injuriously affected by detention, under subsection 2, where there's a suspicion of suicidal intentions, and under subsection 3, where there's a concern that the person has been a victim of torture. You're familiar with that rule and the system as it operated at the time.
Yes, I am.
In your experience, was there a full understanding of those 3 separate components of Rule 35 by the staff who were operating the system?
No, the working understanding would be that Rule 35 directly dealt with victims of torture and the assessment under that part. And I would say if you was to ask a member of staff within the centre what Rule 35 meant, that's what they would talk about, and they would have little, if not any, understanding of the other sections that fall and form part of Rule 35.
Rule 35 reports, of course, aren't done by detention staff. They're done by a general practitioner, medical staff. Did you have any experience of what their understanding was in terms of those 3 separate components?
My understanding was that they interpreted it. Well, let me start again. Apologies. The only context in which we talked about Rule 35 with healthcare was in relationship to determining whether someone was a victim of torture or not. I don't recall any occasion where it was used for any other purpose.
And I think you're aware from your knowledge that there's never been a Rule 35-2 report where a doctor suspects a detained person of having suicidal intentions issued at Brookhouse in the period between 2013 and 2021.
Yes, and that stands in stark contrast to those detainees on ACDT.
Yes, which we talked about before. What was your experience of what detained persons' attitude towards Rule 35 was and the process for obtaining a report?
I'm unaware of what their attitude would be, simply because I don't remember or recall any conversations with detained persons regarding Rule 35.
In relation to the ability of the Home Office to be aware of incidences of self-harm or suicidal intentions in relation to detained persons, they would be aware of those you mentioned before the break in relation to Part C notifications. Can you explain what a Part C notification was?
So Part C is part of the IS 91 risk assessment, and the Part C is where you update that risk, and that would be completed normally by OSCAR 1, which would be the operational duty manager of the day. They'd also be made aware of risks of suicide and self-harm through the ACDT notification, which was the process where when one was open, the Home Office would be informed straight away as well. So they would have had working knowledge from various documented sources, Part C, but also the actual ACDT itself.
And you talked about your concern that there were many of those types of documents, ACDTs, in relation to suicide attempts or serious self-harm, but there weren't any Rule 35-2 reports correspondingly. Was it your view that an ACDT opening in relation to a suicide attempt should trigger a Rule 35-2 report?
It was as though the Home Office had accepted the... Fundamentally, it wasn't. Does that make sense? So actually, that was the working practice.
Continuing then in relation to Home Office oversight, in particular in relation to those who were vulnerable, you've talked about the various ways in which they could be aware of that. Were also Home Office managers present in the centre to take part in the Rule 40 and Rule 42 reviews?
Yes, so it was common practice that the Home Office would be in attendance during every Rule 40 and 42 review. I don't recall an occasion where I undertook one without them being present. However, it was noticeable that very rarely did the Home Office staff actually enter the cell in which the detained person was being kept or engage in any form of meaningful conversation with them.
And in terms of where those reviews took place, they'd be on the CSU.
Yes.
Were you aware at all of the CSU and E-Wing being conflated as being seen as the same thing by staff in relation to where those who were vulnerable or with self-harm issues were sent?
To all intents and purposes, E-Wing was dual certificated for the use of Rule 40 and 42, as well as the Care and Separation Unit, and commonly E-Wing and would be referred to as the CSU, the Care and Separation Unit, as well. So they were one of the same thing.
And were there concerns about that? Was that a problem?
I would suggest that it is a problem because it detracts from the very nature of the Care and Separation Unit, where you're using it as a normal wing as well to facilitate mainly charter flights to reduce disruption to the main wings A, B, C and D.
So just in relation to your view generally then on Home Office oversight in relation to those who were vulnerable either through their history as being a victim of torture or through self-harm and suicide attempts, what was your view about the efficacy of Home Office oversight in relation to that element of the population of Brookhouse?
I would say that in general, the Home Office oversight of Brookhouse was absent.
Moving on then, you have mentioned in your statement at paragraph 147 onwards that there was, in your view, a culture of institutionalized racism at Brookhouse. Firstly, what do you understand the term institutionalized racism to mean? What do you mean by that term?
So institutional racism, from my perspective, is where you have ingrained in the DNA, the fabric of the institution, that overarching culture of separation, of racism as well. And when we study racism and the sociology behind it, the new forms of institutional racism as well, where we refer to groups based on nationality, and kind of conflate that down, is how I would describe it. And I think in my statement as well, I give a more in-depth explanation of my understanding, which refers to the Macpherson report and the definitions which were brought around that inquiry.
Did you yourself witness any overtly racist behaviour by staff members towards detained persons in your time?
So I never witnessed anyone calling people derogatory names, but I did raise, as I state in my statement, issues where when Lee Rigby tragically was murdered, members of staff placed Union Jacks in the staff office as well, which I raised significant concerns about because that was wholly inappropriate for such a place.
And does that sort of incident exemplify the institutionalised racism that you've referred to in your view?
So I would say that the inquiry has already heard far more significant evidence of overt racism within it, but my own experience was that as described.
At paragraph 151 of your statement, you comment on the BBC footage of DCM John Connolly using a racial slur. What was it that was significant about the reaction of others, in your view, about that incident?
I think the issue is the inaction of others to challenge, and that for me is one of the profound signs that this isn't a few rotten apples in the barrel, that this is taking place within a institution and a staff culture where it is endemic. And actually, evil reigns when good people stay silent. And the silence of the good people, the good members of staff, is just as tragic as the actual vile behaviour demonstrated by the few.
Was there training on race awareness and diversity during your time at Brookhouse?
There was very limited training around race relations at Brookhouse, and any training to be meaningful is hampered by the actual nature of the operation itself.
And so that training was inadequate in your view. What was it particularly that made it inadequate?
I would say this issue of there's a difference, Chair, between training and education. And actually what we need is people with an educated mind to work in these places where training is a mere veneer, which is wholly inadequate to deal with the complex issues which staff would need to face on a daily basis.
I'd like to move on to a different topic, and that's control and restraint, or the use of force in Brookhouse. Firstly, do you have any particular training or qualifications that are relevant to control and restraint and the use of force?
So to be clear, I'm not trained in control and restraint. I am trained in physical control and care, which is a physical restraint system developed by the National Tactical Response Group. I've also studied 156 deaths through the use of physical restraint, mainly on children, the youngest being 7 years old. I've also studied conflict management extensively and the use of conflict resolution, but also the need for a tactical response if all else fails. So I'd say I'm widely read and have read most journal articles referring to physical restraint as well.
And you've had the national training from the National Tactical Response Group?
Yes, and on 2 occasions I've been a consultant to the National Tactical Response Group too.
Did that training address the risks or drawbacks to using force in this type of setting?
So that training is mainly focused around the physical application of techniques. There is confusion within the training where they make reference to prison service orders which have no legal standing within a privately run IRC, and the training has limited time spent on de-escalation techniques as well. So it is more around the physical application of force more than anything else.
And so were alternatives to the use of force trained at all, or just in a very limited way?
So as part of the CNR package or training package is de-escalation techniques, but I would say that would take maybe an hour or so within the context of that wider week. But what I would also say is that the skill set of physical force, or the application of force, is a completely different skill set than that of de-escalation and negotiation, and therefore having the same person delivering both sets of training is most unusual. And I think throughout the world the only place where that really takes place is New York Police Department, where everyone else says a negotiator isn't a tactical expert. Does that make sense? So the conflation is deeply unhelpful.
And does the training address the potential vulnerability of detained persons on which the use of force is being used?
So there is some PowerPoint slides regarding that, but within the wider context of the training, that has very little, if any, emphasis.
And was there any distinct training on the use of force on victims of torture or detained persons who had other traumatic experiences, or those with mental illness, or was it a general training
There was
against all
no
detention.
training to my knowledge on that. It was generic.
So, in your view, was that training package suitable for the application of force in an immigration detention setting, given the makeup of that particular population?
I believe that is inadequate, the training package, and actually things like, for example, Chair, people under duress would naturally go to their native tongue, and therefore even if they could speak English in a stress-free environment, they would defer automatically to using their first language. And actually there was no ability when dealing with incidents or critical incidents or negotiation to deploy a translator, for example. So those very basic things which you would suggest are foreseeable within an IRC, there was no ability to do when things went wrong.
And what was the staff's experience, to your knowledge, of becoming involved in use of force? What type of response would staff members give to having to become involved in that type of procedure?
So I think that it's very clear that there was a group of staff which would normally always be chosen if there was a planned intervention. You could look at a shift roster and know from the very start of a shift how the shift would go, and if there was an incident, you could pretty much tell what members of staff are going to be involved in that incident. And therefore it exacerbated, as I describe in my statement, that alpha male macho culture within Brookhouse.
The types of situation that force could be used on detained persons, there could be a planned use of force, or it could be spontaneous in response to a particular incident. Is that
yes,
right?
Yes, that is correct.
In terms of the planned use of force, there was meant to be supervision of that by a more senior member of staff. Is that right?
That is, as the CNR manual states, correct.
Did that happen in practice?
It depends what you see as a more senior member of staff. It would normally be placed upon the Oscar 1 of the day to be that senior member of staff.
And was that happening in practice? It was Oscar 1 who would supervise?
In practice, it would be the Oscar 1 or one of the Oscars that would be overseeing the use of force, but the evidence also shows that's been submitted to this inquiry that on occasions that Oscar would actually take part in the use of force, and that's a very dangerous position to be in, because to all intents and purposes you no longer have anyone separated overseeing the incident.
And Oscar 1, was that a level of management at DCM?
Yes, the DCM, Detention Centre Manager, and it should be noted that there is no extra training to become a DCM. It is purely length of service.
There would be a debrief after a use of force, and there would also be a use of force report written. Is that right?
Yes, so each member of staff taking part in the use of force, or indeed witnessing the use of force, should be completing a use of force report form.
And what was your view about the effectiveness of those mechanisms in addressing or challenging any poor practice in the particular use of force?
I would say that a use of force report form is written post the event, and from the member of staff's perspective is written with a specific agenda, simply to cover themselves and to justify what they had taken part in.
Was there a culture of open learning from experience of use of force or not?
There is no culture of open learning regarding use of force. Where the wealth of evidence suggests is that when you have an incident that requires use of force, that should be actually an opportunity to learn, but also engage with the person that force has been used on.
And did that routinely happen? Were detained persons engaged with about their experience of that use of force?
They were never, let me start again, sorry. The only time that a detained person was ever engaged in reviewing the use of force would be during the Rule 40 or Rule 42 reviews, which would normally take place 24 hours afterwards. But when we say review, it was my experience that in practice no review actually took place. There was no sufficient inquiry into the root cause of the use of force, and there was never a desire to establish the detainee's perspective of the incident. And I draw your attention to the incident in my statement, where in fact I one day on the Rule 40 review went in, asked the gentleman whether I could sit on his bed, and asked him the open question, can you tell me what happened yesterday from your perspective? And the Oscar 1, Adam Clayton, turned round to me and said, we're not here to talk about that. And it was at that point that I had to point out that we was there to talk about anything that I wanted to talk about as the duty director. And as the detainee explained their side of the story, it became very apparent that things didn't go as they should have been, and that they had truth in their story.
From your experience of the use of force during your time at Brookhouse, was there anything in particular that was driving the reasons for the use of force there?
The main reason for use of force, or the two driving factors, was removals, to effect the removal, because we would be fined as G4S if we didn't present a detainee to the escorts on time. And the second thing was operational stability. So actually use of force, and on the evidence and statements that have been submitted to the inquiry, it's very clear that use of force was used wholly inappropriately, simply for moving people around to prepare for deportation, moving them to E-wing, where actually I cannot see for myself any legal justification for that whatsoever.
Did you raise particular concerns about use of force during your time at Brookhouse?
So the times where I witnessed inappropriate use of force was during investigations, and there was one incident which I recount in my statement, where a gentleman had come into the centre, and on his paperwork it was clear that he had mental health issues, and force was used on him. And I recall that I found no legal basis for that use of force, and that actually his needs weren't met at that time. And in fact, according to the Home Office policy, he should never have been there in the first place.
What was the response of senior management when you raised those concerns?
So I don't recall the outcome of that investigation, which I did, but I do recall that no one was sacked for it, and also that the police weren't informed of a potential assault on a detainee, which, if the use of force is unlawful, that is exactly what it is tantamount to.
Thank you. I just want to ask you very briefly about one further aspect about training generally. The training provided to DCOs and indeed DCMs in terms of detention staff, in your view, was that adequate in terms of protecting the welfare of detained persons, or was there more to be done?
I would say that the training is woefully inadequate, and the training was designed solely to meet the criteria set in the contract, and actually wasn't done to ensure that we had educated and trained staff who were capable and competent to deal with the issues that they would face.
And so what would training need to address in terms of care and welfare of detained persons to be adequate in your view?
So firstly, I would say that it shouldn't be called training, it's an education, and that actually they firstly need to understand the philosophical underpinning of the work that they're going to do. Then they need to understand the theory base that's based on that philosophy. Once they've understood the theory, it's only then that you start thinking through the practical application. The problem with only teaching technique is when the technique fails, staff have nothing to fall back on.
I'd like to move on to complaints and whistleblowing. Are you aware of the complaints and the whistleblowing procedures at Brookhouse?
Is that for staff or detainees or both?
Let's start with staff.
Okay, yeah.
Are the two separate? Are complaints and whistleblowing separate?
So whistleblowing is coming out of an act of law where the person is protected, and complaints is separate to that. So there is a separation by definition, yes.
And was there more than one avenue in which to raise complaints or concerns?
So you could raise them with your line manager, and then G4S operated a whistleblowing hotline as well. And technically there's a whole raft of other places which you could go to, which I have gone to between 2001 and 2016.
We've heard evidence from Mr. Tully and indeed from Mr. Syred that DCOs who had witnessed behaviour amongst their immediate line management, which they were concerned about, weren't confident in raising complaints with their line management because they would be complaining to the very people they were concerned about. Was that your experience at Brookhouse?
Yes, and the problem with that is that when you have staff operating in an environment where they are under fear of attack and isolation, complaining about the people who essentially would come and save you if you were attacked or isolated, I think is a deterrent in its own right.
So if you raised complaints, which indeed you did, were you confident that action would be taken by those above you?
So from 2001 onwards, I've raised complaints with my line managers within G4S. I've raised complaints through the whistleblowing helpline at G4S. I've raised complaints with my MPs, with a bishop. I've raised complaints with Kent Police. I've raised complaints with ministers in Parliament. I've raised complaints with a whole raft of people to no avail. And therefore, from my own personal experience, I can stand or sit here today and say that it was a futile exercise raising complaints within this context. The system and processes were flawed, and there was no or little inquiry into the reasons of this. And that's demonstrated clearly where G4S have stated, for example, that a large majority of their whistleblowing complaints in UK and Ireland emanated out of Brookhouse. Well, surely that should have raised concerns. There needs to be sufficient curiosity. And then why would you raise concerns to the Home Office, which hire advertising buses to drive around our streets, telling people to go home or get arrested? Why would you raise complaints about the hostilities of staff against detainees when you had the Home Secretary herself stating that she wanted a hostile environment? Who can you turn to that actually cares? And that very reason is why we're stood here today in a public inquiry, because seemingly no one did care.
So what do you believe the staff members of G4S's attitude towards complaints and whistleblowing procedures was? What do you think they thought about them?
What the staff on the shop floor, as it were?
Yeah.
I would say that they were acutely aware that if you wanted to speak out against your fellow members of staff, you were going out on a limb and you would be isolated. And I think it was very brave of those that did speak up, but the simple fact that the majority of staff didn't speak up is both an atrocity in its own right, but also evidence that they were silenced by their own peers.
You mention in your witness statement at paragraph 303 that you've witnessed staff who have spoken out as being marginalised. What sort of thing would happen? How would they be marginalised?
Oh, I would say they were marginalised socially. They were marginalised in practice, in the sense that they would be left on wings by themselves or not spoken to. We've got evidence of marginalisation as well of, I think Mr. Syred has put in his statement around things being etched on his locker and things like that. There is evidence which I've submitted as part of my statement where staff were marginalised through lack of promotion or indeed demotion within the centre for speaking out too.
And what effect do you think that had on the rest of the staff who witnessed that type of behaviour?
I would say the effect was that they were silenced and became complicit by their silence as well. And I think that's important, that actually the theory of the few rotten apples, it takes one or two people to commit abuse, it takes a community to cover it up, and staff essentially by not speaking out covered it up, and they were negligent in their duties as actors of the state and as officers by not speaking out.
Are you aware of any whistleblowing allegations at Brookhouse resulting in any disciplining or sanction of staff members as a result of complaints or whistleblowing?
No, not to my knowledge. And in fact, I am aware that there were occasions where there were whistleblowing allegations made against myself. And I can sit here today and say at no point have I been in a formal disciplinary in relationship to them. And on only one occasion, I think that I was ever interviewed. And it was the case that whistleblowing complaints were dealt with by an external agency. They would produce a report to the managing director of the business unit, who would then in turn ask the director of the centre to investigate. Well, if you're the director of the centre, why would you want to expose your centre for being negligent in things?
Moving on then to complaints by detained persons, you deal with this at your in your statement at paragraphs 311 onwards.
Mm-hmm.
There was clearly a system for detained persons to complain in writing through filling out a form. Were detained persons, in your experience, aware of that system?
So there were things in place to make them aware of that system. There was posters placed on their units, and there was complaint forms, I believe, in the 12 most common languages. However, it was the experience that they were worried that by complaining, they would hamper their case, their immigration case, and therefore there was that first line deterrent of not complaining. But then there's a second issue of all the time you're in that closed environment surrounded by the staff who you may want to complain about. There is no element of safety for you to complain against them until you're removed from that environment. And therefore there's a profound issue within the system just on that point alone.
So were there obstacles to detained persons making complaints?
So there's no physical obstacle in the sense that the complaint forms were on the wings. They were able to take one, fill one out and place it in the locked box on the wing, which would be collected by Home Office staff. But actually, psychologically, I would say there were many obstacles to make complaints. If staff were fearful of making complaints and they could go home at night, then we can't even imagine what it must be like for detainees to make complaints who are unable to go home.
And was there any type of support or assistance in place to try to overcome those type of psychological barriers to detained persons complaining?
No.
Do you think that would be helpful?
I think having a complaint system which is effective, robust, in this context is deeply complicated because of the very nature of it. I would say the biggest thing that should happen is actually the increase to independent legal advice, because then your complaint can be heard and dealt with and managed in a proper way.
In your statement, you mention mental health advocates,
Yeah.
and that they might be of assistance for those who are particularly vulnerable. Is that still your view?
That is still my view, but I think it's important to go, that isn't enough either, but it's a step, certainly a step in the right direction, yes.
And we've mentioned the contractual obligations of G4S a number of times. Where detained persons complained about something which wasn't, which G4S had no contractual obligation to provide, what was the response in relation to those type of complaints?
So if there was a complaint where there was no obligation on the contractor to provide that service, the complaint would be not upheld.
And how did that affect the detained persons who were complaining about those types of things?
So I've never spoken to them after that, but I know that there was that general feeling of not being heard, not being listened to, because actually any person in the right mind reading those complaints would say, yes, that's a complaint that should be upheld. The problem is when you're in a contractual relationship, by coming outside of the remit of the contract, you're on a hiding to nothing, and therefore you have to draw the line somewhere.
I want to then just deal lastly with oversight mechanisms, independent oversight mechanisms. Part of that that was in place was visits by the Independent Monitoring Board, the IMB, who we've heard something about
Yes.
previously. Did you have any particular engagement with the IMB during your time at Brookhouse?
Yes, so I would go to the meetings with the IMB. I would see them in and around the centre as well. And if I was a Silver Commander and managing an incident, part of the protocol would be invite the IMB to come into the command suite to observe as well.
And what was your experience of how effective they were, as those visits were, as an independent oversight mechanism?
I think to have oversight mechanisms like that is the horse has already bolted. I would say that the IMB, although on paper is a useful tool, and I think it is a useful tool, to have people outside the institution coming in and walking around freely, I think it's limited, and in fact I would suggest that an over-reliance on them is foolishness. And I would draw your attention to the IMB report on Brookhouse of 2020, where they describe Brookhouse and the practices around it being inhumane, with high levels of force being used, high levels of self-harm and mental health issues. If we want to ask the effectiveness of the IMB, one would need to ask the question, what action was taken following the 2020 report?
Another part of independent oversight was Her Majesty's Inspectorate of Prisons, Hmip. They visited Brookhouse to inspect, and that visit would take part in two parts.
Yes.
Is that right? There would first be an initial visit, which is described as unannounced. Was there any advance warning of that first unannounced visit?
No, so you'd get a phone call just before they arrive at the gate telling you that they're coming. So you may have a maximum of maybe 1 or 2 hours notice, but that's about it, to be honest. Less than that.
And then the second visit you refer to as a triangulation visit. What do you mean by triangulation?
So the way HMIP work, which I would say is very good in principle, is that they would first attend site and undertake a very short walk around the facility, and then they would bring researchers in and undertake surveys of the detained population. They would then go away whilst that survey is processed, and then based on the data that survey brings to light, they would come back and then triangulate that data to see if it worked out in practice. And so they'd be looking for supporting evidence or evidence to the contrary to bring about their conclusions. And it's in that interim period between the survey taking place and the triangulation that extensive work would be undertaken within the centre by senior managers and staff to ensure that the best possible outcome would come on their visit. So files would be audited, for example. Staffing would be looked at in great detail. Conversations would be had on whether or not we'd want to give certain members of staff annual leave during the inspection. And money would be spent on decorating the facilities as well. In short, for a senior manager, it was an open checkbook that week between the initial inspection and them coming. And I would say that Hmip are the only organisation following Panorama to actively want to learn from me and sit down, which we did, and we met following that Panorama. I appreciate G4S did ask me to take part in their inquiry, but I deal with that in the statement on the reasons why I didn't.
And so just dealing with the preparations for that second visit,
Yes.
done at the behest of senior management, what was the purpose of that? Was it to create a more positive impression or a positively false impression?
Oh no, so the phrase that Ben Saunders was used is, if the Queen was coming round your house for tea, you'd get the best china out. And so it was to create an overwhelmingly positive experience. It would be, for example, as basic as the week during the inspection, you would have Kingsmill bread.
Were there any other particular limitations to Hmip inspections, or was that really the main one?
So the main limitation, what we need to understand, is an inspection is an inspection. It's not an inquiry, it's not an investigation, and therefore they are limited in their scope, but given that, they do a rather good job in what they do.
Would Hmip then make recommendations following those inspections?
Yes, they would make recommendations, and what's fascinating within the immigration estate is that there's no compulsion to act on those recommendations in any way, shape or form, and in fact the Home Office and G4S would routinely reject recommendations from Her Majesty's Inspectorate.
Thank you. Yes, thank you, Chair. Those are all the questions that I intend to ask Reverend Ward. Do you have any particular questions now?
I do have just a couple of follow-up questions. Some of them from slightly earlier in your evidence, and my apologies for that.
Oh, don't worry.
We talked a little bit about, or you were asked rather, a little bit about debriefing, and you made the comparison to different settings in which you may have clinical supervision.
Yes.
Do you remember either being involved yourself or observing other staff being involved in any form of debriefing after incidents that may have been distressing, such as a self-harm incident or a serious attempt at suicide, for example?
So if there was an incident where the centre was placed into command mode and the command suite was open, following that incident there'd be what's called a hot debrief, and then there would be a cold debrief taking place after that. However, I must say that I would say that's more procedural than therapeutic or indeed learning, if that makes sense.
Was there ever such a thing as I've heard them described in other settings as care teams that may come in after an adverse incident to offer support to staff? Can you remember such a thing?
So there was a care team in place. However, it was recognised by senior management that it was wholly ineffective and didn't work in practice.
Can you remember when that was, approximately?
Oh, so that was there when I was there in 2011, 2012. Okay, but there was no coordinated attempt to deal with that.
Okay. And then just two other brief questions. So you talked about staff transitioning from Dcos to Dcms.
Yes.
I just want to clarify that I've understood you correctly. You mentioned that it was more a process of time in service than necessarily having any training. Just to clarify, did they have to go through the process of an interview, of a selection panel in any respect?
Yes, so there was an interview process for that, which had a role play in it, I believe, as well as interview questions. But it wasn't as though you had to go on a course, pass it to show competency and then apply for the job. It was merely, if you was good at interview skills, then you'd get through. But also, I think it's important to state that if you needed DCMs wouldn't be appointed. You wouldn't keep the post vacant until suitable people came along.
Okay, understood. You also mentioned that one of the Oscar 1 role was undertaken by a DCM. Are you aware of whether there was any additional specific training for undertaking that role as Oscar 1?
So when I first started, there wasn't any training whatsoever, and that was something that I highlighted at Tinsley House. And so I developed a very short course to try and upskill the staff in becoming Oscars, as it were. But even myself, as the person who wrote the course, would say it wasn't suitable or sufficient to actually deal with the complex task that they were undertaking.
Thank you. And then my final question. Earlier on in your evidence, you talked about there being gaps on the roster, and on some occasions there may be names of staff members who actually were just not available because they were long-term sick, for example. In those instances, from your memory, would that simply mean that that person would just be missing, that post would be vacant from the day? So even if you should have 3 staff members, you maybe would just have 1 or 2? You'd
have to reduce it down. So, for example, at night time, that's where you'd find an acute pressure. On occasions, you would have a case where a staff would work a day shift and then stay on working the night. So they would be working in excess of 20 hours. Consistently without a break. You would have situations where one member of staff would leave the wing doors open and have to work between 2 wings. The issues with that is that the call panel for that wing is in that wing, not the other wing, and so they would have to move between the 2 things, which is wholly unsuitable. And I would say if there was a fire, it would be a challenge to evacuate swiftly and safely.
Can you remember any incidents where there was such an insufficient number of staff that more drastic action had to be taken, such as drafting in staff from elsewhere or moving detainees to another centre, for example?
So to my knowledge, there was multiple occasions where we had to move staff from Tinsley House to Brookhouse and then run Tinsley House dangerously low throughout the night. I'd also say that on many occasions, Brookhouse was dangerously low of staff during the nighttime periods too.
Thank you very much.
No,
That's the end
thank
of my
you.
questions. Thank you very much for your evidence.
Thank you. I think the suggestion is to start at 9:30 tomorrow morning, if you're agreeable.
Indeed, unless we have any objections from anybody. Okay. Thank you again. I know it's not an easy process, but I very much appreciated you coming, so thank you.
No, thank you for your time too.
I shall see you at 9:30 tomorrow.
Thank you.
Thank you.